So our discussion is on legal Latin. Okay, so this is part one. There are 15 expressions in Latin that we will be discussing. One of my in a seminar that I attended, no, a speaker said that no, that the speaker is an older lady, and she was speaking about, of course, legal English and the expressions that we use in our pleadings, the pleadings that we submit in court. And he said that, and she said that, let us no longer use Latin terms or Latin terminologies. Okay, so there was a murmur from the crowd, no, and the lady lawyers tried to explain herself, saying that, look, we were taught of these expressions when we were in law school, and we were made to memorize the expression and memorize or and learn how to use these particular expressions, and we know how to use it. Now, when we make use of these Latin terms, do you think that the judges who will read our pleadings will be able to understand it? The judges are younger than us, and I doubt that they would be able to understand much of the expressions that I'm trying to convey when I make use of the Latin terms that we use in our um, expressions in law. Okay, and she has a point. No, she has a point really that uh, the judges are usually younger than the lawyers. These particular lawyers, and Roman law, I think, is no longer used in or taught in law schools. Okay, so it is in Roman law that some of these or most of these particular expressions are explained, no, and are used. So we will be discussing. I will be giving you the Latin term, and then the meaning of the expression, and then an example on how it is used in uh, in Philippine jurisprudence. Now, the examples that I will be giving you are examples that I took from cases in the Philippines, no, in Philippine jurisdiction. So the first is ipso jure. Okay, ipso jure. So ipso jure is defined as or means by the operation of law. So the expression essentially says that uh, it is automatic because the law says so. You don't have to do anything in order to make it so. Okay, so it is automatic that because the law provides that it be so. Okay, so here's an expression now in an example in Philippine jurisprudence. Now, the laws of Filipino citizenship ipso jure terminates the privilege to practice law in the Philippines. So let us exchange the word ipso jure or automatically, no, with automatically the term. Okay. The laws of Filipino citizenship automatically terminates the privilege to practice law in the Philippines. Automatically, in the sense that we have to, of course, to get into the definition of by the operation of law. So automatic by law. Okay. So when a Filipino citizen loses, oh no, yeah, if a Filipino loses his citizenship, then automatically no, his privilege to practice law is also terminated. No, so a requirement in the practice of law in the Philippines is that the lawyer must be a Filipino. If you are not a Filipino citizen, then you cannot practice law. So ipso jure. Another term, in flagrante delicto. What does this mean? It means caught in the act of committing a crime. Okay, and maybe to as a memory guide, no, in trying to determine the meaning of this term is the term flagrant, no. So flagrant is an obvious and overt act. So a flagrant violation. Okay, so in flagrante delicto. The expression is used in this way in Philippine jurisprudence. The accused was arrested because he was caught in flagrante delicto of the crime of illegal possession of dangerous drugs. So caught in the act of committing a crime. Another expression, prima facie. Okay, prima facie. Yeah, forgive me, of course, no, if I might be mispronouncing these words because I did not study Latin. None of us studied Latin. Okay, so we do not know actually the correct expression unless, of course, you browse the internet and determine how it is pronounced. So prima facie or prima facie. Okay, so it means on the face of it or as things seem at first. Okay? So at the first instance, okay, that is prima facie. This is how it is used in Philippine jurisprudence. Such prima facie evidence, if unexplained or uncontradicted, can counterbalance the presumption of innocence to warrant a conviction. Okay, so prima facie evidence actually is the quantum of evidence required for the prosecution to file a complaint in court. Okay, if it is uncontested, no, or uncontradicted, and it shows on its face that the person could have committed the offense, then such is a prima facie evidence. The next term, ex gratia. What does this mean? It means a gift with no obligations attached. Okay, so it is something given gratuitously or given out of the graciousness of one's heart. An expression in Philippine law, in jurisprudence, this is how it was used. The extension of one's probation was ex gratia, an act of liberality on the part of his employer. Okay, so the employer extended the probation of one, out of the goodness or out of the liberality of his on his part. Okay, so ex gratia. Uh, you can also refer to the term gratis. Okay, gratis means free. You know? Or the expression gratis it amore. Okay, something given out of love freely. Okay. Then we have de novo. Okay, de novo um, means to start again. Okay, so usually this is you would hear this expression in trials de novo. Okay, trial de novo, meaning that despite the fact that there was a previous proceeding, there was a trial. Okay, the court can direct that a new trial should uh, um, again be done. Okay, so how it was used in jurisprudence proceedings before the Court of Tax Appeals in the exercise of its exclusive regional jurisdiction are in the nature of trial de novo. Okay, so despite the fact that there was reception of evidence or there was a trial previously, but because now in this particular expression or in this particular example, because this is an exclusive original jurisdiction by the Court of Tax Appeals, they will receive evidence again. Okay, so a trial de novo. Then the term per se. Okay, per se. I think you are familiar with this term. Okay, per se means on its own or all alone. How was it used? In one of the cases here, prevailing jurisprudence holds that unless a nuisance is a nuisance per se, it may not be summarily abated. Okay, so in effect, what this means is that a nuisance per se can be summarily abated. Hmm? And that's the positive expression of this negative expression. Okay. So nuisance per se, on itself, on its own, it is already a nuisance. No? Examples of nuisance per se, no, loud noises, banging noises that irritates the ears of or disturbs the peace in an otherwise peaceful community. Okay, or um, what usually happens during um, the rainy seasons. No, if you are familiar with this, that people during the rainy seasons would release no, the contents of their septic tank along the canals. Okay, and it not only is something wrong, no, it irritates the nose. It is also a danger to health. So this is a nuisance per se. Okay. Now the counterpart of nuisance per se in jurisprudence is nuisance per incidence. Okay. It only becomes, it is not a nuisance by itself, but it becomes a nuisance because of certain circumstances. Okay. Then we have this next expression, locus standi. Locus standi. Locus standi means the right to be heard in a court. The three, okay, in the example, the three base their locus standi on direct injury and also from transcendental importance doctrine. Okay, so in the example, it pertains to three people, no, stating that the reason or the basis of their standing or the right to stand before the court is based on direct injury. Okay. So when a person files an action in court, okay, usually one of the things that lawyers would see is whether the complainant has a locus standi. Does the person have a standing in court to file the action? Does he have the right to be heard? Okay. Is he directly uh, injured, okay, by the acts of the client that would allow him, no, the right to be heard in court or to have locus standi. Another expression, inter alia. Inter alia. What does inter alia mean? Okay. So it means among others or in addition to other things. Okay. This is how it is used in one case, no? Uh, Article 14, Section 8 of the Constitution of the Philippines provides inter alia that all waters of the Philippines belong to the state. Okay, so we can substitute this, no, with the term among others or among other things. So uh, Section 8 of the Constitution of the Philippines provides, among others, that all waters of the Philippines belong to the state. Okay, so it means that uh, there are other things, no, other than this, which has been provided in the expression. Then we have ex post facto. Ex post facto means after the event. Now you would hear of ex post facto, particularly in discussions on uh, on the Bill of Rights, no, or in the discussion on the limitations of the powers of the legislature to pass laws. Okay, so a prohibited act or a limitation to the power of Congress to legislate is to pass ex post facto laws. Okay, so laws that take effect or that or laws that are passed after the act, okay, which tends to punish it, and this is of course proscribed or prohibited. So an ex post facto law is one, no, this is merely one, no, is one which makes criminal an act done before the passage of the law. Okay, so this actually ex post facto laws are laws that punishes acts that were committed before the law was passed. Okay, so I think, an example that I usually give is during the early years of uh, the internet. No, when a Filipino, when the Filipino who created the "I love you" virus, okay, was threatened to be sued, the- or to be extradited. But the problem was there was no law in the Philippines that punishes the act of the person who created the "I love you" virus, which of course damaged a lot of computer systems now and caused injury or damages to other people all around the world. Okay, but he cannot be prosecuted in the Philippines. Why? Because there was no law that punishes such particular act. Okay, after that, the Philippine legislature passed the passed laws, no, that punishes, okay, the creation of these viruses, no, computer viruses, malware. Now the question was, can they now make use of that law to punish the creator of the "I love you" virus? And the answer is no, because that is an ex post facto law. You cannot pass a law that punishes an act which was committed prior to the passage of the law. Okay. Another expression is pari passu. Okay, pari passu. Pari passu means equally or with no distinction. So the example is, the cash payments shall be made semi-annually over a period of 10 years on a pari passu basis with the bank creditors without interest. Okay, so if there are several bank creditors, cash payments will be made equally to them with no distinction. So that is the expression pari passu, equally or with no distinction. Then the term ex parte. Okay, ex parte means a legal action or application pursued by one party only. There are instances in our uh, in in our jurisprudence, in law and in practice, that a party is allowed to present evidence ex parte. Okay, and an individual may present his evidence ex parte without the participation of the other party. So an example is that the defendant deemed to be as in default, the court may now authorize the clerk of court to receive evidence ex parte. Okay, so because the defendant was deemed to be as in default, the party, no, who is the complainant, may present evidence before the clerk of court without the participation of the defendant. Why? Because he was considered to be one as in default. Okay, so even without the participation of the other party, one is allowed to present his case. So ex parte presentation. Then the term mala inse. Okay, mala inse. I think most of, if you are law students, you would have met this particular term in first year, no? Criminal Law 1, a discussion on the distinction between offenses that are mala in se and those that are mala prohibita. Okay, malum prohibitum, malum in se. Mala in se means an act such as murder, which is a crime in itself. Okay, the act is already a wrong. Okay, it is already a crime that it shows no the evil intent of the person. Okay, a wrongful intent. An example, the example, our example, not taken from jurisprudence again, says that the law has long divided crimes into acts wrong in themselves, called acts mala in se, and acts which would not be wrong, but for the fact that the law prohibits it. Okay, so we have a distinction of mala in se and mala prohibita. Mala in se means that it is wrong in themselves. Example, murder, to kill another person. Okay, theft is mala in se. Robbery is mala in se. Now, vis-a-vis the malum prohibitum or mala prohibita. Okay, where uh, an example of an offense, malum prohibitum, is possession of firearm no, during the election period. Okay, so the carrying firearm in itself is not wrong. In itself is not wrong because there is no evil intent. You holding a gun, okay, there's nothing wrong with that. There is no malice, okay. But because it is prohibited by law, it is prohibited by law, then it becomes an offense. So that particular act only becomes an offense because there is a law that prohibits it. Okay. And then we have in terrorem. Okay. I have to admit that in terrorem is a term that I only once encountered, and it was in contracts, not as is expressed in in our jurisprudence. Now, I was trying to find no the term or the situation where I found this particular term. But in terrorem means an implication of threat. Now, in other jurisdictions, in terrorem particularly applies to contracts, that there is an implication of threat in the contract, which essentially now invalidates the contract itself. But in our jurisdiction, in the manner by which they used the term in terrorem is this, no? Criminal statutes have general in terrorem effect resulting from their very existence, meaning that the existence of a law, a criminal law, implies a threat against persons, okay, against those who intend to commit the offense. Okay, so because under our criminal laws, a crime that has been defined usually carries with it the penalty. Okay, so the penalty is the threat. If you do this, then you will be punished with this. Okay, so that is in terrorem. Then the next term, habeas corpus. Habeas corpus. Um, you would have heard of this, no? During the term of President Marcos, okay, during the declaration of martial law, there were discussions on habeas corpus cases, and then again during the time of Duterte, okay, where there was a suspension of the privilege of the writ of habeas corpus, okay. So habeas corpus is a legal remedy against wrongful imprisonment. So, um, if you recall your constitutional law, a writ of habeas corpus is an order coming from the court directing a person, okay, directing a person to present, okay, the body of the person who is under his or her detention. Okay, Uh, so this is to question the legality of why a person is being detained or being withheld his freedom. So, an example, the court issued a writ of habeas corpus ordering petitioner to bring the child to court. Okay, so this can also be used in custody battles where one party, no, um, takes the physically, no, takes a child, no, in under his or her wing, no, preventing the other parent from visiting or to contacting the child. Okay, that the remedy that is available to this parent is to file a habeas corpus case, and the court will issue a writ of habeas corpus directing the other party to present the child before the court and to explain, no, uh, or to yeah, to explain or to give reason why his that particular child is in his or her custody. Then the last of the terms that we'll be discussing this evening is de facto. Okay, de facto. De facto means taken as a matter of fact, even though the legal status is not certain. So, in the discussions on governments, okay, we have de facto governments and we have de jure governments. Okay, but this can also be used, no, for officials, no, when there is an issue as regards the validity or the legality of one person uh, holding position, okay, and exercising the powers and authorities of that particular position. Okay, so the example here is that a judge de facto is an officer who is not fully invested with all the powers and duties conceded to judges, but is exercising the office of judge under some color of right. Okay, so that is de facto. So the question as to whether he has fully or that the person has all the or is uh, has all the necessary legal basis in order to hold the office is in question. Okay, so but despite that particular question, he performs his act. No, then he is a de facto officer. He performs his act and exercises the powers that are related to that particular position. Okay, he is a de facto officer. And of course, no, when um, in an instance where he has already acquired all the necessary um, authorities to grant him the right to hold that particular position, then he becomes a de jure officer. Okay. So similarly, in de facto governments versus de jure governments, a de facto government, an example would be a government that takes over from a duly elected government. Okay, so at that instance of taking over from a duly elected government, this government that takes over probably by force is a de facto government. And that particular de facto government can acquire the status of a de jure government, no? Probably by recognition of the people, which already gives the government the mandate when the people recognizes the government. And other states Other nations also recognize the government as the representative of the state. So, in that essence, the de facto government becomes one a de jure government.